This is docket 20365 FC, People of the State of Michigan versus Matthew Weston Goff. Counsel, your appearance for the record.
Andrea McCray, appearing on behalf of the people.
And good morning, Your Honor. Frank Harrison with the Ingham County Public Defender's Office here on behalf of Mr. Goff, who appears in person, standing in counsel table to my left, and appearing in conjunction with attorney of record on this matter, Steve Bucks.
Yeah, good morning, Your Honor.
You may be all seated. There are a number of issues today. There is a motion in limine to exclude evidence. And there's also a motion by the people. Of course, I can't find it buried in my file, but anyways, it's a notice, I believe, of intent to introduce other acts. All right, thank you.
Your Honor, if I may, I think that there's, what I have is that there is a other acts motion that the people have filed regarding acts of, that are in sexual nature.
Yes.
That's a big topic. There's also an other acts motion I filed regarding, the missing gun, that touches on tampering of evidence. I originally filed a motion in limine to exclude testimony of the victim's other sexual conduct. I think we should start with that because that forces the defense to put their defense not on record, but make it available, and that will make my other acts motion clearer when we know what their defense is. So perhaps I should start with I originally filed a motion to exclude other acts of sexual conduct because it was brought to my attention in conversations with brother counsel, Mr. Feigleson, that he wanted to get into the fact this victim has made allegations because the defendant's brother, as you well know, Your Honor, was convicted twice, really based off of her testimony alone.
Correct.
I filed that motion because I believed that there was going to be an attempt to argue that these were just allegations. She makes them all the time. They're similar, blah, blah, blah. After I filed that, the brother counsel filed a response to my motion, but they also filed a motion to introduce giving formal notice that they wanted to pierce rape shield.
They wanted to what?
Pierce, like pierce the veil, yeah.
Yep.
So, in talking with my appeals unit, I am going to concede a number of those, but I think it should be brought up very narrowly at trial. My trial strategy now is going to be essentially that this poor girl was a sex slave to both of these men. But I want the defense to make a very clear record that this is the defense they're pursuing, this is strategy, and that, my understanding of their defense at this point in time is that everything that happened with Tiffany and her dad is true. And that's why they want to talk about it, because the case law, which they cited Massey, it's reliable, right? There's 2 verdicts that say that it was true. And so my understanding is that they are arguing Matthew Goff, everything that she said about Michael Goff is true, it happened. But what she's remembering about Matthew Goff is mistaken identity, or she doesn't remember it correctly. So I think with that, I will turn it over to defense. And I just want a very clear record that this is the strategy they're pursuing. Because I think there are issues. I think a jury hearing that a poor little girl from 3 to 11 was raped day in and day out by these 2 men is prejudicial. But if that's their strategy, that's their strategy.
Well, let me just say, before I hear from defense, so you can respond to this. The prior conviction cannot be used for her sexual history or credibility, but rather the idea that this conviction leads now to a possibility or defense of mistaken identity theory. Correct?
That's my understanding.
That's correct, Your Honor. That's
So
exactly what
there's no issue if it's narrowly construed like that. But if we're going to attack that other case, that she's not credible, that none of this happened, that's no, that's a big no. We're gonna follow the law here, and you're only allowed to use it for mistaken identity. That is an offense, or that is, I'm sorry, a defense that is allowed in Pierce's rape shield.
Correct.
For that limited purpose, is
Correct.
that your intent?
Judge, it is. I'll let Frank argue the majority of it, but since I did participate in the first conversations with Ms. Correa, that is essentially what our position is, at least from my perspective. I think Mr. Silverthorne had a different position, and I think the client may also feel that the allegations against his brother are also false.
Don't care if she's gonna testify, and he's gonna testify to that, unless he was present, an eyewitness, that belies two juries, it belies the credibility of the witness, and that's not coming in.
Good enough, Judge.
People would agree with that?
Oh, yes.
Just making sure that I'm consistent with the law. I mean, I'm not new to this law. It's very well written. Many cases, it's been challenged, and there is a dividing line. Counsel, what record would you like to make?
No, Your Honor, I was just gonna agree exactly with what you said. I think based on the fact that you're tailoring, obviously what our client believes regarding the other case is neither here nor there in front of us. It is our intention specifically just to introduce this evidence to basically explain exactly the accusation. And as both sister counsel has pointed out, as per theory of what exactly our case is in fact correct, that it's just a stake of mistaken identity. We are not here to challenge that other case at all. We accept that consequence and we accept that conclusion of that as it is.
And let me just stop you, counsel. We have a speeding limit here. You cannot speed, because I will give you a ticket or a timeout. My court reporter, especially as we go through this very intense trial, is gonna need a lot of breaks, and it's gonna take 2 weeks longer. She's a human being, takes down what you say, and out of respect for her and the jury pays attention to this. This is a difficult case. If you're gonna talk that quick, we're gonna have a lot of breaks, and I might put you in lockup. Quit it. Thank you.
My apologies, Your Honor. It's an unfortunate sort of habit that I have.
Break it.
But I will rein it in. But however, to just move back to the point, Your Honor, just to reiterate what I just previously said, we are not here to challenge the previous case. We accept that conclusion as it is. In fact, we are building it as part of the thesis of our case, and we accept what Your Honor has put on the record. If we can speak to it to a limited perspective, we are happy with that.
Thank you. Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide me the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes.
Raise your hand down. So you've heard this argument. I understand what you might believe. Let me just tell you about beliefs. As attorneys, in response to me, tell me what they believe, I don't care. I tell them, take your beliefs to church, got evidence. Don't care what you believe. I also don't care what you think. Tell your mother what you think, tell your brother what you think, tell anybody else what you think, but not me. And the reason is I deal in evidence. The jury can only rule on evidence. So you want to talk about evidence? Great. You want to talk about what you think or believe? It has no place in this record because it is not relevant. Do you understand that?
Yes, I do.
Great. So as to those issues, counsel, and if he chooses to testify, which he does not have to, but I want credible, relevant evidence, not what someone thinks or believes. And I know you both are astute attorneys who understand that, but I need to have, you to have that conversation with him if he is going to testify, which again, he doesn't have to. But I don't want to muddy up the record or have another trial because it's muddied up. And we need to have a good, solid record, especially if it doesn't go your way for appeal. So think and believe, not in my world. We deal in evidence. Everybody understand? Sir, you understand?
Yes, I do.
If you don't, you have any questions about it, you decide to testify, talk about what that means with your attorneys. You have two very good attorneys, and I am certain they can explain it further. Both counsel agree and understand?
Yes, Your Honor, you are very clear.
Yes, Your Honor, we're very clear. And Mr. Goff, you understand what she just said, if you chose to testify, we would not be able to bring that up, is that correct?
Yes.
You have any questions about that?
No.
Okay.
Great. Next matter.
Your Honor, before we move on, and I'm sorry to this, I drafted kind of like a proposed order, and my plan for today was to, after everything is said and done, is go back to my office, draft a bunch of proposed orders, make sure they're okay with it, and then send them to you. But I think it's important that we put this on the record because defense and I are in agreement with what I have written out, plus we added one line. Can I
You
approach?
may, counsel, you've both seen that?
Yes, Your Honor.
Okay.
Yes, we have, Your Honor.
Have you signed it or as approved?
We have not signed it. but
I want to have a record of us talking about this, and then I will write it up later. But, so the only things I added is that defense can use for limited purpose of mistaken identity, and I put in or sexual knowledge, or explaining sexual knowledge. And then we already went over the same in the back. Just in case I die or something, between now and going upstairs, and then we don't have.
So you don't want me to sign this, you are going to present it as written here and then I will sign it.
Yes, Your Honor.
Thank you, appreciate, would you like a copy of this?
Yes, Your
Everybody?
Honor, please.
All right, we will, make everyone a copy, you'll fix it and then I'll sign it and be sending it to everybody. Counsel, since you've agreed like this, we don't need to do it under the 7-day. I'm allowed to sign it as long as it comports with this.
The
On
people.
behalf of defense?
Yes, Your Honor.
Be agreeable.
All right,
Okay, Your Honor. Next issue that is pretty easy to resolve is the defense filed a Stanaway motion.
yes.
The motion at this point, and I'm sorry to step on y'all's toes, is legal because, the long story short is it came to my attention that I believed Tiffany disclosed in therapy. I immediately reached out to Mr. Feigelson, said, I think you should file your Stanaway motion. And during that time, I went and made sure I could get the records. I was able to obtain those records within like 2 days. So we were able to provide brother counsel CMH records. I believe it's 180 pages. There were no records from Small Talk for therapy because they remove or delete their records after 7 years in compliance with the law. But I did provide him a letter from Small Talk that said that.
Can I just ask you, in the evidence on the other golf case, do the people have that Small Talk information somewhere in storage?
So what I have, Your Honor, is forensic interviews. Those I do have, absolutely. However, the victim, she might have been confused, but she thought she went to therapy at Small Talk too. And so,
They do offer it,
yes,
so that might be
So-
why.
in an abundance of caution, and I really had no idea, I asked them if they had any clinical records for Tiffany. And they said they did not because they got rid of them after 7 years. I did get the CMH records, and Your Honor, I did all this in attempt to avoid an in-camera hearing and delaying the trial. That's why I did this. I would have liked to have an in-camera hearing because based off what my detective told me, nothing in those CMH records, I think if Your Honor reviewed them, and I think brother counsel will agree with me, he would have said there's nothing here, we're moving on. You know, you don't get any of this. Is that correct? Michelson, is that your understanding after reading them?
Yes, correct, Your Honor. I was, before she stood up, I was about ready to withdraw her motion, but
Okay, so withdrawn. Is there a further record you need to make? And that
That-
should be in the order.
That if defense changes their mind and wants to bring up anything from those records, that they make an offer of proof outside the presence of the jury before doing so.
I don't have a problem doing that.
good enough for me, Judge.
All right, so let's put that in the order as well.
Yes.
And then are are you finished writing?
Yes.
All right. Are you then ready to discuss 768.27A?
Yes, which will be it will be a long argument, so bear with me.
That's what I'm here for.
I know, I just wanna, okay. So, Your Honor, we have three charges, 3 acts that we charged here. Fellatio, digital penetration, and the groping of the breasts between the ages of 3 to 11 years old. The victim described additional acts, and she described not only sexual assaults, but she described behaviors designed to lower her inhibitions and increase the likelihood that she would remain compliant so that the defendant could continue sexually assaulting her, which I know Your Honor is well aware is commonly known as grooming. She made these disclosures in her forensic interview, additional disclosures in her forensic interview on July 26, 2018, at the preliminary examination on June 19, 2020, and at an interview with a detective on November 24, 2025. Your Honor, I just want to describe some of those acts so that they're in the record. And I know they're in my motion, but I think it's important when I talk about the probative nature of these, giving specific examples.
Counsel, would you mind standing at the podium?
Sure.
Give me a moment to collect it. Thanks. Thank you.
Was I too quiet?
No, I just want to make sure that it's all picked up. It's just better at the microphone. You're not generally too
I
quiet.
know, I was like, that's usually not something I hear from people, is that I'm actually too loud. Okay, so in her forensic interview, Your Honor, she talks about how the defendant would show her sexual videos, cartoon characters, fairies, monsters, and other computer-generated images of people and things engaging in sexual acts. He would take her to private sites and make her watch these sexual videos. He would tell her to listen, to follow what the girl was doing in the videos, and that he would follow what the boy was doing. The defendant would show her the sexual, would show her the sexual videos every time he sexually abused her. The defendant would sometimes take a video of her on his phone during the sexual abuse. He would threaten her with katanas. She described these katanas as swords with blades on either side. He specifically would say to her, "I will chop your hand or your finger off if you don't do as I say." And if he couldn't find the katanas, he would use a knife. Tiffany described that she was between 3 and 5 years old when the sexual abuse first happened. It would always happen on the bedroom on the 3rd floor. She described the first instance as the defendant being hesitational, and that as it continued, he would be less hesitational each time. She said the last time she remembered being sexually abused, she believed she was 11 years old, and that the defendant's man parts, which she clarified is where he pees from, touched her chest, that his hands groped her breast, and that his hands touched her vagina and went inside and outside. And that the defendant's man spot, which she clarified was where he pees from, went inside her mouth. And that the man spot would touch everywhere from her head all the way down to her kneecaps. It would touch inside and outside of her body. She described white and gooey stuff that would come out of the defendant's man part and land on her stomach or her chest. In the preliminary examination on June 19, 2020, she described under oath the defendant showing her pornography, which included videos of women or children having sex with men or boys, that he would bribe her with candy or movies, that he would threaten her during the sexual acts if she said no or if she asked for a break, that he would force her to rub his penis with her hand, force her to put his penis in her mouth, that he would grope both of her breasts, He would rub her vagina, and all of this happened more than one time. The interview with law enforcement on November 24th, 2025, Tiffany described this defendant, Matthew Goff, would force her to watch pornographic videos for years before he did anything physical to her. And while she was forced to watch pornographic videos, the defendant would stay seated playing video games next to her. When she was younger, the defendant showed her a lot more pornography with cartoons. As she got older, it changed to real people as opposed to cartoons or computer generated. She remembered a specific time when the defendant asked her, "What was your favorite movie?" And she said Tangled. And he said,
What, Tangled?
Tangled, Tangled, okay, which is a Disney movie. And she said the defendant found pornographic videos of Rapunzel and Flynn Rider having sex and showed it to her. She said he would show her pornographic videos up to 4 times a month. She said the defendant flashed his gun at her in a threatening way to force her to watch these pornographic videos and engage in sexual acts with him. She recalled the defendant always having a pistol on him that he wore around his waist. She further indicated he would force her to touch his penis while watching pornographic videos. She has a specific memory of kneeling before the defendant during one of the sexual acts, and that he would ejaculate on her face multiple times. Your Honor, clearly, that is a lot more than 3 charged acts. However, I'm asking that Tiffany be allowed to discuss all of those instances. Because majority of what I just talked about are listed offenses under 27A, with the exception of asking her for candy and bribing her with candy. Everything else is a listed offense. Because he engaged in criminally sexually abusive activity when he allowed for, arranged for.
Okay, hold on, because he engaged in criminal sexually
Sexually abusive activity, sorry, Nancy, when he allowed for, arranged for Tiffany to engage in passive sexual involvement by forcing her to watch both adult and child pornography before and while he sexually assaulted her, or while he touched his penis, or for his sexual gratification. I would note threatening her with weapons like knives, katanas, and a gun are all potential charges of a CSC first or second with a weapon. And now that's not charged here, but it could have. It could have also been accosting for a moral purpose. So why, Your Honor, is this evidence probative? So grooming is going to be a huge part of this case, as you just heard from all the information I laid out. Not only is it going to be a huge part of Tiffany's testimony, it's going to be a huge part of Barb Welke's testimony and our expert testimony. And it's going to explain to the jury why she didn't disclose for years and why there was a delayed disclosure. Because it's not only the disclosure between the 4 months between when she disclosed about her father and this defendant, but it's the 8 years from when she was 3 to 11 years old. Now, I'm offering it under 404B if it didn't meet the 27A, but I think 99% does. But under 404B, that is the non-character purpose of common scheme or plan, and now identification, because they have made that a material fact at issue. And also I'd say, Your Honor, that 404B is the list of non-character reasons is non-exhaustive. And I point to the case of People v. Starr, STARR 457 MISH 490 1998. And that in that case, evidence that the defendant had committed other acts of sexual assault against another victim was admitted to show intent, which would be relevant in our case, the CSC's second charge. Existence of a scheme, plan, or system by which the defendant accomplished the abuse, and to show absence of mistake or accident. Offering to show it as grooming is a proper purpose, because I'm not offering it as propensity if I couldn't under 27A, because it could come in under 404B for all of those other reasons for a non-character purpose. So the main issue then is going to be, as I'm sure the defense is going to bring up, is, well, this is unfairly prejudicial. So we then turn to the 6 Watkins factors. Number one, the dissimilarity between the other acts and the charged crime. Your Honor, they're very similar. These acts didn't happen in a vacuum. They're part of an ongoing exploitive relationship between this defendant and the victim. The temporal proximity, which is the second factor, they were all happening at the same time. She said, every time he would sexually assault me, he would show me these videos. Almost every time he would threaten me. Factor number three, the infrequency of other acts. Your Honor, she's going to testify that sometimes the defendant would show her pornographic videos up to 4 times a month. These aren't random acts that happened 20 years ago. This is all part of this horrific 8 years that Tiffany was essentially a sex slave to this man. Factor number 4, presence of intervening acts. I don't know of any. Factor number 5, lack of reliability of the other acts. Your Honor actually had the ability to see Tiffany testify twice and find her credible. 2 juries found her credible on the testimony of her brother. But even if we forget all of that and if we think she's not credible, in this case, we have evidence in the form of other witnesses coming in to corroborate things she's saying. And we have corroborating evidence from the defendant's own hard drive of all of these images of adult pornography that corroborate what she's saying. And finally, number 6, the lack of need for evidence beyond the victim's testimony. Your Honor, it is the utmost probative value in kid cases where we don't have DNA, where we don't have fingerprints, where we don't have video of this man raping Tiffany. It is all about her. It is all about her credibility. It's all about what she's going to say. And so it is the utmost value in cases like these where there's not physical forensic evidence. So, Your Honor, for all of those reasons, I would seek to admit the testimony of other acts that Tiffany is alleging. Where things get a little difficult is what was found on the defendant's hard drive. Why I think that is difficult? Because I want to offer some of it as extrinsic evidence. I don't want to just offer the detective sergeant talking about it. So let's talk a little bit about what was found on the hard drive. On the defendant's hard drive were over 80 images of suspected child sexually abusive material. 3 of the images were confirmed child or children previously identified by law enforcement, according to the National Center for Missing and Exploited Children. 76 artifacts were recovered that depict computer-generated images of suspected underage persons engaging in sexual acts. That would include characters from popular children's movies like Scooby-Doo, Harry Potter, Avatar the Last Airbender. One example that really sticks out to me, Your Honor, is there is a picture of a young Hermione Granger that you will know is a character from Harry Potter when she was a child. She is naked on a bed. There's a wand next to her. She's spread eagle. Her vagina is clearly visible. And what is so fascinating about us finding that image is that Tiffany said her Matthew Goff would show her in videos of Hermione Granger being gangbanged. Your Honor, we also found on his computer bookmarked an adult woman that has an adult male penis in her mouth, and it's a meme. And what I mean by a meme is that it's a picture that has writing on it, and the writing on that picture is, quote, "My niece's look told me she was begging for my approval when going down on my large cock." And as you know, this defendant is the uncle to Tiffany, and Tiffany is the niece. Your Honor, beyond that, there were numerous images and videos of suspected adult pornography. including searches and URLs for pornography sites like Pornhub and XX videos, which I expect Tiffany to testify. She knew he took her to, and we have friends from the 2nd grade that said Tiffany showed them XX videos. The suspected CSAM would obviously fall under 27A. The other issues like the adult pornography stuff is arguably 404B. I will say, note for the record though, the image with the writing, "My niece's look told me she was begging for my approval when going down on my large cock." There's nothing illegal about owning that picture, right? The people's position is that goes to consciousness of guilt. And that's actually what I'm gonna argue is a confession. And it's the best kind of confession because he didn't even know he was leaving it as a confession. And they found it before they even knew she made a disclosure, that she even made a disclosure about Tiffany, because they did that search warrant months in April or March, and then she didn't disclose till June, and she knew nothing about that search warrant. However, I think that why I'm seeking to admit all of that stuff under 404B, because it is very similar to what she says. And she says that the grooming changed as she got older, right? So it was like the cartoons and whatever other weird, sorry to say that word, stuff until she got older when it was real people, it was adult pornography. It also corroborates her account. It corroborates what she's saying. It involves similar age victims. And it looks very similar to what she describes. For example, there's no allegation in this case that the defendant put his penis inside of her vagina or her anus. That's only her dad. But the defendant commonly would make her suck his penis, or he would finger her vagina. What we found on his computer, that suspected CSAM, is a number of images of what looks like to be 4 and 5-year-olds, cartoonish CGI, real-looking kids who are being forced to suck a man's penis. So it's very corroborative of not only what she describes that he did to her, but what he made her watch. However, we did go yesterday, both brother counsels and I, to go review the CSAM. Your Honor, it was very disturbing. And then when I originally filed my motion, I noticed all of it and figured I would just pick and choose what I wanted to show. However, I think in all candor to the court and my, what my duties as a prosecutor, there are things that I think are too inflammatory. Those things would include a picture of what appears to be a 14 to 19-year-old child in front of a bunch of Beanie Babies with the words "rape me" written across her stomach. There's a bunch of even adult pornography with horrific things written on the women like "rape me," "whore," "man's garbage slot," and they arrow pointed to the vagina, "cunt," "whore." So, Your Honor, what I can tell you is I'm not going to admit any videos. I'm not going to admit any of the adult pornography, extrinsic evidence. I do want to still talk about it because I think it corroborates what she says. I won't seek to admit any sadomasochistic images. I know there's one that I recall of what appears to be a very young, maybe toddler, being anally penetrated with ropes being involved. So
Let me just stop there. So understanding that piece, would that be true if needed for rebuttal? Couldn't that be used for rebuttal if needed, despite it being inflammatory, depending on the evidence that comes in?
Yes.
I just want to clarify.
Yes, yes. And so that's why I think that we should, before we maybe hold the issue of the extrinsic evidence, and really what I mean by that is showing the jury photos of CSAM, is we hold that in abeyance, wait until her testimony comes out, and then I pick which images I think I want to show, and we have, you know, a hearing outside the presence of the jury, maybe early one day before trial, and make a very clear ruling on what images we think should come in. Because they're bad. I mean, they're horrific, really. And so, I mean, you know, like, I can't show the jury an infant with a pacifier in its mouth being raped. Like, that's inflammatory. So that, but I absolutely think my detective gets to talk about it in the very least. And I am gonna offer certain images. It's just gonna be, it needs to be in a very limited capacity. So.
Thank you. Response,
Would you like me at the podium, Your Honor?
please.
This will be very quick, Your Honor, admittedly. So after talking with APD Feigelson on this matter, based on how sister counsel has presented what exactly she looks to present, we would be in agreement. We believe that unfortunately it would be probative and we don't have a particularly great argument against it. So instead of wasting the court's time, we'll just accept that what prosecutor is putting forward is acceptable.
I appreciate that because my ruling is exactly that, that it comes in under 768.27A and MRE 404B. There's no reason to exclude it, especially with the cautionary approach of the people. I think that it's wise, but also we can do any offers of proof during trial that are needed. And further, although there's been assertions that some things will not be shown to the jury depending on the way the evidence comes in, it may be, as I said, admissible for rebuttal. So that is not all off the table. So I will sign an order, please include it.
I will, Your Honor. The only other, I did file a motion to introduce other acts regarding the missing gun. Oh, here it is, okay. And that, you know, as Your Honor will recall, at the bond hearing, I informed Mr. Goff that this evidence would be probative in the trial, would be corroborative of the victim. He told this court under oath, he knew exactly where the gun was, that it was at his brother's house. He then told a very different story to his attorney and then told a very different story in court 6 days later when it suddenly disappeared. And he had no idea where it was. I did request that those transcripts from Nancy, who did them so fast. I did provide that to brother counsel, Mr. Feigelson. My intent would be to have my detective read parts of that transcript into the record.
Counsel?
Yes, Your Honor, I've had a chance to, I did have a chance to, and I appreciate Nancy getting to us that fast. I did have a chance to review her motion, Your Honor. I'm gonna stand by what Mr. Goff said. He believed that it was at his brother's house. That was 6 years ago, and for some reason it wasn't there. He has no idea where the gun is. I don't think you can make any inferences of a guilty mind or a guilty conscience from that. He thought the gun was at his brother's house. Something happened with the gun. He has no idea where it is. I don't think you can argue at this point, given how long ago it's been turned over to his brother, that this is evidence of a guilty mind. Thank you.
Thank you. Was the gun registered and was there a license?
The gun was registered to Matthew Goff. I don't know if he had a concealed carry license, but the gun was certainly registered to him. And what's interesting is his brother, Brian Goff, actually purchased the gun, and 2 days later, it was transferred into Matthew Goff's name. And that was years ago. I think that was, can't remember, years and years ago. What's interesting though, Your Honor, is that this defendant told his counsel, let's be clear. He didn't say on the record, I believe it's at my brother's. He said, it's at my brother's. And he was very clear and repeated it more than once. That's number one. Number two, that story then changed to, we turned the gun in to MSP, check with MSP. So I had MSP do a whole shakedown to see if this gun, which of course they have the serial number, of course it's registered, it has never been turned into MSP. So that's not true.
Was it ever reported as lost?
Never. He never reported it as lost either. And then we get to court, and he says, okay, my third story is, I don't know where it is. I haven't seen it. And what's interesting is if defense wants to make that argument that he doesn't know where that gun is, well, that's fascinating, because when the troopers went out to go do the search of his house he consented to, that canine dog who specialized in smelling guns hit extremely hard on his closet. So if they want to make that argument, then I'm going to come in and say, well, guess what? That gun was recently there, or a gun was recently there, because there's no other reason a canine dog would hit that hard.
Was any weapon or ammunition found in that closet?
There was not a, there was parts of like a weapon that couldn't work, but not like a gun that was operable. Does that make sense?
Yes, but would that throw off the tracking dog for weapons if there were parts of?
I don't think so, because the way that the detective described it to me, it was like a I could be wrong, but the detective, like, and the other troopers were like, he knows where the gun is. This gun was here recently.
Okay, so that would be though fair game for cross, because there were pieces of weapons.
Yeah. Yes, absolutely.
Okay. Counsel?
Yes, Your Honor, that's accurate. There were pieces of other guns found there, but again, I don't think you can make any inferences from this. Gun was registered to him. He legitimately thought it was at his brother's. He did say in open court, I gave it to my brother. Since then, he's not certain what happened to it. I believe him.
Your Honor, it's being offered to prove defendant's knowledge, evidence of guilty knowledge and consciousness of guilt.
Okay, but also there's an issue of exculpability or inculpability and credibility of the witness. And she says there's a gun. So during this time frame, there was a gun in the home, correct?
Yes, when you look,
Okay, then it's coming in. Cross-examine whatever you want out of it, but it seems to me to be relevant, and the jury can make whatever inference they want.
and there's photos I'm going to admit from the search warrant before they even knew any of this, of a gun safe with guns and the pistol in question. I'll prepare an order on that as well.
Are there any other matters we need to address?
Yes, Your Honor. I do want to put on the record that both brother counsels and I reviewed the suspected criminally sexually abusive material yesterday. That included 88 images, but it also included a number of other images of adult pornography and other.
Yes, you stated that.
I know. Can you just confirm that that's true and that you guys went and saw it?
That is accurate. Myself and Mr. Harrison went yesterday with Ms. McRae as well as the lead detective on the case.
Lead detective was not there.
Sweet.
Also yesterday in court, I let Feigelson, I showed him all of my electronic file, and showed him the watch guard and the V drive, which have digital evidence in this case. I created a spreadsheet of all the discovery I have. I'm gonna provide that to Brother Counsel. In that, I have proofs of service for every item. There's over like 130 items. I believe he has everything at this point. There are gonna be a few things that trickle in. They're not material in any way. Can you confirm that that's correct?
Yes, Your Honor, Ms. McCray and I did discuss the discovery relating to this case. I believe that we have every piece of evidence. What was prompted by that was my paralegal, Ms. Douglas, emailed out at my direction to set up a discovery meeting with Ms. McCray. We're waiting on that spreadsheet of the evidence that was turned over, but my belief, based on what she showed me yesterday, I believe we have everything has been turned over, Your Honor, at this point. And if there's something that we don't have, I'm sure we'll be able to work it out.
And then finally, Your Honor, I just want Brother Counsel to put on record that chain of custody is not gonna be contested, because I don't wanna be in a position where, and I've had conversations with Mr. Feigelson where he's told me chain of custody is not gonna be an issue.
Let's be very clear, chain of custody of what particular evidence?
The hard drive. And
That's right,
I
yeah.
doubt you're gonna contest the katanas.
Same thing, Your Honor, that there's no issue with changes.
Okay,
So no issue with chain of custody for any of the physical evidence.
so chain of custody would only come in if someone is surprised outside the presence of the jury, then I'll make a further ruling, but otherwise it comes in.
Correct, Your Honor. I think we do need to address one other thing, Your Honor.
Okay,
I believe, Mr. Goff, we had discussed, not only myself, but Mr. Silverthorne, about you taking a polygraph exam, is that correct?
That's correct.
You understand you statutorily have a right to take one, is that correct?
Yes, I do.
And you, not only I talked to you about, it, Mr. Silverthorne did as well, is that correct?
That's correct.
And at some point you chose not to take one, is that correct?
That is correct.
And we talked about, not yesterday, as well as other times, the benefits not only to taking them, but the risk associated with taking them, is that correct?
That is correct.
And at that time, you chose not to take one, is that correct?
That is correct.
And after hearing everything today, you know you have a right to take one. What is your choice with regards to taking a polygraph?
I will decline.
And that's your choice, no one's forcing you to do that.
That's correct.
Or
anyone
additional-
promise you anything or threaten you to make this decision?
It's my own decision.
All right, and you've made that after you discussed all the issues with your attorneys, you've heard my rulings, I know you know about your brother's case, all of that, you've made this decision?
Yes, I did.
And you're satisfied with the representation of your both counsel?
I am.
Thank you. Any other matters we need to address?
Not on behalf of the people, Your Honor, thank you.
I believe we've handled all matters, Your Honor.
All right, thank you. So one of my issues, I believe I gave you the date of Monday for jury selection.
Correct,
Which
Your
would
Honor.
be fine. However, I have to be off the record between 11:30 and about 1 o'clock, which would be right in the middle of jury selection, which I don't like to do, although we could give them a break. So the option would be, I do now have that Friday open, so we could do it the 6th or we could do it the 10th. It's up to you.
Your Honor, I'm fine with doing it the 10th. Okay, I'm fine with doing it the 10th. I think this is gonna be, what?
I mean the 6th, Ms. McCray? She said the
Either
6th.
Friday or Tuesday.
Oh, no, wait, sorry.
No, she said the 6th or the 10th. So that,
Never mind, I apologize, Your Honor. I heard
what
wrong.
would you rather do?
No, I didn't realize the 10th was an option. I'm good with the 10th.
Yeah, me too.
Okay.
So I think,
Well, and I figured you all might need with these rulings a few more days to review and put things together, so it doesn't break my heart either. We're getting to this trial. We could also do it the 9th. It just would release everybody for an hour and a half, and then it just makes it a really, really, really long day. But it also gives the jury an opportunity to have lunch. So I can still do it the 9th. I just have something that is on my schedule that cannot be moved at that time. So it's up to you.
I would prefer the 10th, Your Honor. I think that this is gonna be a long jury selection. I mean, because not only do we have to talk about, even though CSAM is not charged, like, that's a very big issue that we're gonna have to bring up to the jury.
Agreed.
So it's gonna be hard to find a jury that's gonna wanna be fair and impartial and hear these facts.
Do either one of you want a transcript of today's hearing?
So,
I just want to give Nancy notice because we are very busy, as you know.
oh, I know, Your Honor.
We would also decline her.
Okay, so is there anything else we need or you need in preparation for the jury selection and the trial on the 10th?
We believe we are sufficient and ready to go, Your Honor.
Your Honor, just for scheduling, so if we do jury selection on the 10th. Oh, that's Wednesday, so we can have that
No,
Wednesday.
it's a,
Right.
yeah, it's a chance, then you have
Okay.
Wednesday to prepare, and then we'll start openings on the 12th. We certainly could do it on the 10th, but generally these kinds of.
11th.
uh,
Am I looking, oh, I'm looking at December 2025, sorry.
Okay,
Okay. Sorry, okay.
These types of jury selection generally take a long time, so I order extra jurors, I will clean them out quickly, so you get a good selection to choose from, and then I will leave the rest of the questioning to you, and so then we will swear them in Thursday, begin openings, is that? the
Yeah, so
plan for
we
you?
won't have Wednesday, but we will have Thursday and Friday.
Yeah, and then we'll go into Monday, Tuesday, Thursday, Friday until we finish this case.
Yes, okay. I expect that it will be, probably a week long.
If we think we are running short of time, I will shorten the jurors' lunches and bring in lunch. It seems to work really well when we just take it 30 to 45 minutes instead of an hour and a half. So if you let me know if there's a congestion of witnesses and we need to shorten the jurors' lunches, let me know and I'll make that happen.
Thank you, Your Honor.
Thank you.
All right, thank you. Bond and bond conditions are continued, and thank you very much for all your extensive work and argument on this. That's all for this record.
Proposed orders and then send it to you guys.
Very good, very good.
No, not orders, she's gonna make, she's got.
All right, guys, thanks.
Okay, wait, I have, did I put in there somewhere the schedule?
I
Oh,
Yeah. it's already done.
I'll try to-
It's something. It's like.
So I leave for vacation on the morning, I will do the 20th.
Yeah.
Oh, yeah.
Okay, we're gonna do Floyd Rush. That was on Judge Sosa's docket.
Yes.
Hey, Brian. The forest, we're doing off the record, so you can,
Oh,
You're
okay.
doing that off the record?
yes, the forest is off the record.
So do you have a next date?
Andrew is working on it.
Okay,
Who are we doing on those services?
Floyd Rush.
this is docket 25-488, I'm sorry, -4844 F8. And Mr. Rush is not yet here from lockup, so I'll recall the case. But everybody's in place.
Yes, for 1 second. Davis is off. I think
Huh?
11 a.m. Kevin Davis is off.
Why?
You know, I'm not sure.
Kevin Davis is off because there needed to be a writ from Clayton County, so that was not
Okay.
done, so it's been moved to March sixth.
Thank you.
And then the
Wait,
two,
March sixth?
Correct, March sixth.
there you go.
Oh, wait a minute, I'm not here.
I was informed by your report that you are here on
Well,
March.
let me just double check, because I don't know all my, oh, March sixth, oh, the Friday, okay,
Yes.
okay.
And then which one, Brian? Let me see something else.
And then 2:30. Tanner Johnson.
Not going.
Correct.
What's next?
I think that's it right now.
You're disappointing me.
That would be, we handled all of the thought motions,
Correct.
so that's, we need some separate times,
Yeah.
Right, because we had a gap in the
Yeah.
schedule.
yeah. And what about college? Do we have, someone covering for Dwayne?
Yes, Your Honor. I believe it is, Stephen Mills.
Okay,
Yeah, I was gone. See,
No, you're good. I think I got everything covered.
and what about, is someone covering for Palmer? Probably no.
Yes.
Okay.
Actually, apparently on that case, Feigelson gonna be handling Luke Major.
Oh, okay. The attorneys. So for college, it's gonna be Stephen Mills. Matt.
It's at 1 p.m.
Major. Change from Palmer to. Okay, and then we're gonna have to change Hutchins to Tennessee, because that's Palmer, we gotta go through and grab a lot of people.
So, yeah.
I mean, I did like
I know,
15.
I know, it's gonna keep going.
So these are trying to change the electric orders. Because usually I will wait.
Just change, they were the same firm, yeah,
Okay.
you can wait, that's just, because it's just cleaner than. I think they'll probably do a mass order or something, I don't know. This is docket 254844 FH, People of the State of Michigan versus Floyd Edward Rush. Counsel, your appearances for the record.
Good morning, Your Honor. Elena Cisneros on behalf of the people.
Good morning, Your Honor. I get one here for Mr. Floyd Rush, who's by my side.
Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide to be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, ma'am.
You put your hand down. Judge Stokes is not available today, so I'm handling some of her cases. And so you'll still be in front of her, but I'm hearing this.
Okay.
Is that all right with you?
Yes, sir.
Okay. And this is a bond motion. I do have, and I'm in receipt of the bond report dated February 24th, 2026. I trust both counsel have it.
Yes, sir.
We do, Your Honor.
Thank you. Counsel, you may proceed with your argument.
Thank you, Your Honor. This is the second motion that I filed on behalf of my client. Your Honor, the bond is still very high for him to be able to get out. He's indigent, and one of the things that I would like the court to understand is that my client being in jail, he has not been able to find stable housing. However, he has been living in a shelter for a long time. Every time that he's out, he has a job, and he still has a job even though he's been incarcerated for a few months now. He plans to live at the rescue mission. And I don't think that it should be taken as a negative factor, because being on house does not mean that you're not going to show up in court. One of the things that my client has done while he was on bound, he was reporting to pretrial services. He has a job, like I said, and there was no other violation beside the fact that he has a new case. There was no other violation of the conditions of the bond. Now, one thing that, considering the factor of the society being whether or not he's a risk for the society or for the alleged victim, there is a confusion here. The alleged victim told the police that she was living with her mother. We have the indication that she was living with her mother, although part of the police report said that she was living at a camp with him. That camp, I don't think that anyone's living in that camp at this time. My client knows where he's going to be staying.
Well, you can't go back to that camp.
I know, Your Honor. So they cannot say that they're going to go back to that the alleged victim was living with him at the camp. That's what I'm saying. That camp, he cannot go back there, she cannot go back there. And we have verification that she was living with her mother. She said that herself. So we have an address where my client should be prohibited and will be prohibited from going there. So that will protect her. And reading the answer from the prosecutor, yes, my client is charged with assault with intent to do great bodily harm. There is also, he has an extensive, criminal record, not that extensive, yeah, criminal record, prior convictions.
What's the status of the 24726 FH case? Because he allegedly committed this while on bond conditions on that case, and those are serious charges. Looks like he was sentenced to jail and on probation.
No, he's not on probation, his probation, he was sentenced to jail and he has completed that sentence, Your Honor.
I have sentenced to 180 days jail and 60 months probation. That's what it says in the criminal history.
Well, he completed that sentence back in October.
The jail,
Yeah.
but he's still on probation. So while on probation, there's another file.
No, this is probation.
He was on bond on that case.
But I wasn't on probation.
He was not on probation.
Okay,
He was
either way,
sentenced after.
probation, bond, kind of the same thing. You have to follow the orders of the court, right? And somehow we end up with a new file. That's a problem for me in terms of public safety and your argument, counsel.
I understand that, Your Honor, but you also understand that he is presumed innocent until proven guilty.
I understand that.
And what is happening now is that he's pretty much serving a sentence for a crime that he has not been convicted with.
Bond conditions, as you know, and sir, as I'm sure Judge Stokes explained, and if she didn't, I will explain, is for your return to court, your compliance out there, and public safety. And it looks like while you were on probation or bond conditions, as the case may be, I don't have all of your information in front of me. I have what's in here in the very detailed bond report. Says that you committed another offense, which has an habitual fourth. So it's count one, assault with intent to do great bodily harm less than murder or by strangulation, which with the habitual offender fourth offense notice is now punishable by up to life. And then there is the domestic violence third offense, which was a 5-year, which now would be a 10-year under that. or no, it would be also punishable by up to life. So we have life offenses while you're out. So let me hear from the people.
I think, Your Honor, I'll be brief. As the court knows, I did file a response to defense's motion. I would ask the court ultimately to not modify bond again. Judge Stokes did graciously modify bond already on October 27th when we were before her. She modified that to what was $100,000 cash surety. She modified that significantly to a $50,000 10%. That was on October 27th of last year. Nothing has changed as far as Mr. Rush's ability to maintain housing. I understand that he is homeless. He was alleged to have been living in a tent at Dietrich Park near Pisano's at the time of this offense, as the court is aware of that location. I have no proof that he was living at the shelter. Not to say that he wasn't, but I have no proof to support that. Ultimately, nothing has changed since Judge Stokes did already modify bond significantly. I would ask that the court leave bond as is. We do have a trial date of March 31st.
Anything else, counsel?
No, Your Honor. Thank you.
Bonds?
I would think something that has changed, that he's still in jail. And he has accumulated more time in jail, and he's in jail because of this new case. And so, like I said, he's being sentenced for a crime for which he has not been convicted yet. And I would still say that, asking him to find housing, because I remember Judge Stokes had stated that if he were able to find a stable housing, she would consider reducing bond again. But him being in jail, it's difficult to find housing. He has a place to go. There are other conditions that could be put in place to protect the society. And so I would respectfully ask the court to reduce the bond for an amount that he can pay.
Anything else you want me to know, sir?
Yes, I just want you to know that I am enrolled into LCC. I have things to keep me busy. I have a full-time job that I can start almost immediately when I get out, so that way I can start making money in order to try to give myself a place. I was in contact with people from Appen House. They had put me on a list for HUD, and they were trying to help me find things. And unfortunately, I ended up in jail. But I don't miss court dates. I don't abscond or anything like that. I was doing well on tether, even though I was homeless, living in a tent. My tether never died, never came critical. And I was just trying to make it a different way, trying to get off the streets, and I ended up here. So, but
What is the likelihood of success on behalf of the people?
Your Honor, I would indicate that it's greater than not. There is independent witnesses in this matter. The victim did, after she was allegedly assaulted, did seek safety or seek shelter at or near Pisano's. At or near Pisano's.
Okay.
And so is she expected to show up for trial?
Yes, Your Honor.
She's been cooperating?
Yes.
Anything else you want me to know, sir?
There were no other.
Without talking about the case.
Okay. I have to say that I have no intention of getting in any more trouble. I want to get out and finish my education, continue my job, and the education that I have with LCC. I acquired that while I've been here. I've also gotten things in other classes, coping skills, DBT, dialectical behavioral thinking, and anger management. I've been doing that stuff. I'm also, like I said, I'm just trying to I want to get out and be positive. I want to start and don't stop.
Council, you had something else to say?
It's in regard to, what the sister council said regarding independent, witness regarding the assault, alleged assault. I would talk to her because if I don't know that there was someone else who, was a witness, so I would talk to her regarding that part.
Given that there was already a file, he was on probation, very serious offense, or maybe bond. Again, I don't have the timeline, but it was orders of this court. And now we have another file and Judge Stokes already reduced bond. The only thing I'm going to say is it says that bond was reduced to $50,000, 10% cash surety, which is fairly low for a life offense. I'm going to add, if it wasn't already, a GPS tether and leave it the same. There is apparently a strong likelihood of success by the people. This was committed while the court was already monitoring him. I have no doubt he'll show up. You have a record of charging your tether and showing up, sir. But the problem is, we were supervising you and we end up with another file. There is an innocence until proven guilty. That is the burden placed on the people for beyond reasonable doubt. You still have all those rights intact. There are different considerations for bond. And bond is safe to the public, and I have and likelihood of success, and I have this other file, very serious, so it is denied, and bond, if it's not already including GPS, does now include GPS. That's all for the record, thank you.
Thank you, Anna.
Thank you.
Maybe Johnny Greenwood next.
Motion to include other evidence, right? Motion and then. Motion for privilege.
Still need this form, practices, and.
I didn't do that, that's a fault there.
What do you need to start doing, like, I might need to turn the station to it. Okay, this is docket 256041 FH, People of the State of Michigan versus Johnny Greenwood III. Counsel, your appearance for the record.
Good morning, Your Honor. APA Bart Buxton on behalf of the people of the state of Michigan.
Good morning, Your Honor. Toby White, I'm here on behalf of Mr. Greenwood, and as you can see, he is with me at council table, or not council table, but podium.
Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth, and comes in perjury?
Yes, ma'am.
Thank you. Put your hand down. Have you taken any medication yesterday or today?
No, ma'am.
Are you supposed to be on medication you're not on?
No, ma'am.
Any sign of fever, COVID, or other illness?
No, ma'am.
And you had enough time to speak with your attorney?
Yes, ma'am.
And sir, are you a U.S. citizen?
Yes, ma'am.
Do you reside on Marlins Drive?
Yes, ma'am.
And who lives there with you?
My mother.
Okay, and are you currently employed?
Yes, ma'am.
What do you do?
I'm a maintenance technician.
Okay. I understand there's going to be a plea today with what you're pleading to. Were you on probation, parole, or bond conditions on another file when this occurred?
No, ma'am.
Thank you. On behalf of the people, what is the plea agreement?
Yes, Your Honor, the defendant will be pleading to count 2, carrying a concealed weapon, and an added count 3, possession of controlled substance less than 25 grams. Upon successful plea and sentencing, count 1 will be dismissed. There is also a Killebrew agreement to county cap at the time of sentencing.
Full, fair, accurate, and complete.
It is, Your Honor.
Full, fair, accurate, and complete.
Yes.
Counsel, you waive your reading count 1.
Yes.
As to counts 2 and the added count 3 on the amended felony information.
Thank you, Your Honor. People of the State of Michigan versus Johnny Greenwood III, State of Michigan, County of Ingham, in the name of the people of the State of Michigan. The prosecuting attorney for this county appears before the court and informs the court that on the date and at the location described below, the defendant in count 2, weapons carrying concealed, on or about October 1st, 2025, at 5015 South Cedar Street, Lansing, Michigan, 48910, County of Ingham, State of Michigan. The defendant did carry a dangerous weapon, to wit, a pistol, concealed on or about his or her person, contrary to statute. This is a felony that's punishable up to a maximum of 5 years and or $2,500 with mandatory forfeiture of the weapon or device. Count 3, controlled substance possession, cocaine, heroin, or another narcotic less than 25 grams. On or about October 1st, 2025, at 5015 South Cedar Street, Lansing, Michigan, 48910, Ingham County, State of Michigan. The defendant did knowingly or intentionally possess less than 25 grams of a mixture containing the controlled substance cocaine, contrary to statute. This is a felony that's punishable up to a maximum of 4 years and or $25,000. Court shall order law enforcement to collect DNA identification profile sample for sentencing or disposition, if not taken at the time of arrest, and against the peace and dignity of the State of Michigan.
Sir, did you understand what was just read?
Yes, ma'am.
So you understand count 2, carrying a concealed weapon is a felony punishable by 10 years
Yes, ma'am.
or $2,500. There's mandatory forfeiture of weapon or device. Any contraband that was seized, controlled substances, what have you, will not be returned to you. Do you understand that?
Yes, ma'am.
And as to count 3, possession of a controlled substance known as cocaine, less than 25 grams, was that a 10-year felony?
That's a 4-year, Your Honor.
Or 4-year, okay. That's punishable by 4 years. Do you understand that?
Yes, ma'am.
All right. And it looks like you signed the advice of rights form. Did you read it before you signed it?
Yes, ma'am.
Did you understand what you read?
Yes, ma'am.
And if you had any questions, your attorney was able to answer those?
Yes, ma'am.
Sir, do you have any questions about your rights at this court?
No, ma'am.
As to count 2, carrying a concealed weapon, how do you plead?
Guilty.
As to count 3, possession of a controlled substance less than 25 grams known as cocaine, how do you plead?
Guilty.
Do you understand that if someone forced, threatened, or coerced you to plead or promised you something we haven't made a record of, you need to tell me that now, because if you come back later and say, Judge, I never should have pled, I don't have to withdraw the plea. So my question to you is, have you pled of your own free will?
Yes, ma'am.
And you did that after you talked with your attorney?
Yes, ma'am.
And you've been satisfied with his representation?
Yes, ma'am.
And do you understand that by pleading, you're giving up the presumption of innocence, the ability to cross-examine witnesses, provide a defense, hold people to their burden of beyond a reasonable doubt, have the right to an automatic appeal. Now, if you want to appeal, you first have to ask permission of the Court of Appeals, and it becomes their decision whether or not they allow you to appeal. Do you understand that?
Yes, ma'am.
Do you also understand that if I do not follow this agreement of a county cap, I can do anything from 0 to 365 days, but if I go over that, then I would allow you to withdraw your plea, and this matter would again go to the pretrial stage. Do you understand that?
Yes, ma'am.
And do you understand that if you violate the law or bond conditions between now and sentencing, I can go over the county cap and I do not have to allow you to withdraw the plea? Do you understand that?
Yes, ma'am.
Has anyone other than the agreement that you've made told you what I will do at sentencing? Has anyone told you what I will do at sentencing?
No, ma'am.
Because I don't know.
Right.
Don't have a crystal ball. I don't know much about your case. I don't even get police reports. When I'm fully informed, then I'll make up my mind. Do you understand that?
Yes, ma'am.
All right, very good. Sir, did these offenses occur on or about October 1st, 2025?
Yes, ma'am.
In the city of Lansing County, of Hingham, state of Michigan,
Yes, ma'am.
at a specific location known as 5015 South Cedar Street in Lansing. You came in contact with law enforcement.
Yes, ma'am.
Were you walking on a bicycle, in a vehicle? What happened?
I was outside the store.
Outside the store? What store was that? Do you remember?
O'Reilly's Auto
Okay.
Parts.
Okay, O'Reilly's Auto Parts. And why did law enforcement stop you or talk to you?
I was having a conversation with my cousin. We haven't seen each other in a long time. Over disagreement, we were talking. I guess they thought we were about to fight or something like that.
Okay, so it might have appeared to them that you were about to get into fisticuffs or attack each other or
Yes, ma'am.
have some kind of assault. Were you talking loudly?
Yes.
Okay, a little bit disruptive, so maybe somebody called them?
Yes.
Okay, and then when law enforcement approached you, did they pull the two of you apart and then ask to search you? What did they do next?
They pulled up and said they got a call of somebody had a weapon on them.
Okay.
I fit the description. They
Okay.
patted me. I had a firearm on me.
Okay, where was that firearm located?
On my hip.
Had you placed it there?
Yes.
And you would agree that it was concealed?
Yes.
And you did not have a license to carry concealed, is that correct?
Correct.
Okay. And you didn't have any special permission or authority to carry it either, is that correct?
Correct.
And you would agree with me that a pistol is a dangerous weapon?
Correct.
And did they find on you cocaine as well?
Yes, ma'am.
And where was that?
Inside my pocket.
Which pocket?
Left pocket.
In the left pocket in your jeans?
Yes.
And you placed it there?
Yes.
And it was cocaine?
Yes, ma'am.
And it was less than 25 grams?
Yes, ma'am.
And again, you didn't have any prescription or license or authority to carry that, is that correct, or to have that in your possession?
Correct.
And that day when you were in contact with law enforcement, were you high?
No, ma'am.
Okay, so you recall what you've told me from your memory. It was a clear memory.
Yes, ma'am.
Okay, very good. That's why I'm asking, sir. Okay. On behalf of the people, any additional questions?
People are satisfied, Your Honor.
Your Honor, satisfied on both counts.
Thank you. And on behalf of the people, was it test done to verify it was in fact cocaine?
Yes, Your Honor, there were true narcs done and it did test positive for cocaine.
And counsel, you're not disputing that.
I am not.
Thank you. Are counsel aware of promises, threats, or inducements other than those already placed on the record?
No, Your Honor.
I am not.
Has court complied with court rule?
You have, Your Honor.
Yes, Your Honor.
Thank you. I find defendant's plea has been freely, voluntarily, knowingly, and understandingly made without any undue influence, threats, coercion, or promises of leniency. I also find there are sufficient grounds for counts 2 and 3 to enter. Count 1 is hereby dismissed along with any outstanding warrants, if any related to this file, those were called and dismissed. Do we have a sentencing date?
April 8th at 10 a.m.
Should be good, Your Honor, we'll meet you.
All right, and the weapon and any drug contraband, paraphernalia, whatever it is, hereby forfeited. However, if that weapon was somebody else's lawful weapon, they are the only ones who can seek to claim that weapon, otherwise it is forfeited. Totally. Do you understand, sir?
Yes, ma'am.
All right, sir, you need to make and keep an appointment with probation. The phone number is on that purple sheet, it's 517-483-6100, but while you're in this building, perhaps counsel, you could show him where to go to the lower level and make, and down there, just while you're in the building, personally make an appointment. You'll need to keep that. They're going to do a very detailed pre-sentence investigation report. We need that for sentencing.
That's fine.
Bond conditions.
I will, I always do, Your Honor. I'll take it.
Okay. Any questions, sir?
No, ma'am.
All right, thank you.
Thank you, Your Honor.
There is one that we can still do tonight. Finally. Christ stump on Zoom.
Mr. Stoke on Zoom?
It appears so, Your Honor.
So what time is he supposed to appear?
At 11. Mr. Carter is here, correct?
Oh, yeah. Right. Is Mr. McCroy Stump here on Zoom or in the building?
Doesn't
He's
look.
not here, Your Honor.
Do you want to try to call him, counsel?
I've tried.
All right, I'm gonna call the case.
Well, I'd ask that you wait if you have other things to do, because I'd rather wait and see if he shows up than have to come back in.
Okay, so here's, I'm just looking at my schedule.
Yeah, we still have
Okay.
Hemoja Green, but that is Stokes' case, so I'm trying to wait for
Okay.
the
Right.
Cisneros.
Just a moment. This is docket 25-2774 FH, People of the State of Michigan versus Kamari, LaCroix Stump. We are supposed to have a plea hearing, that's what it's scheduled for. I have, well, counsel, your appearances for the record.
Good morning, Your Honor. APA Vernon Buxton on behalf of the people of the state of Michigan.
And please, the court, David B. Carter Jr. on behalf of the defendant who is not present.
He is not present. I will give him until 3 p.m. today. If he does not appear by 3 p.m., bench warrant bond forfeiture. I know counsel's very good at reaching clients.
I will
All
do my
correct.
best.
Thank you. Mr. Green also? Mr. Green?
Yes.
And what about, who's the counsel?
That's,
Oh, all right. Have you talked to him?
that's just So's case.
Got it. So let's do it.
We don't have the prosecutor for that one yet.
Okay.
That's all we have left.
This is docket 24598 FH, people of the state of Michigan versus
Umoja.
Umoja. Thank you. Green, counsel your appearance for the record.
Good morning, Your Honor. Elena Cisneros on behalf of the people, along with Agent Farr from probation.
Good morning, Your Honor. Amanda Tringle, Office of Public Defender, appearing on behalf of Mr. Mildred Green, who's present to my right.
Please raise your right hand. Do you swear or affirm that the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
I do.
Thank you. Put your hand down. So this is Judge Stokes' case, but she's not available today, so I'm handling it. Are you all right with that, sir?
Yes,
And have you had enough time to speak with your attorney?
yes,
Have you taken any medication yesterday or today?
no,
Are you supposed to be on medication you're not on?
no,
Any sign of fever, COVID, or other illness?
no,
And have you had enough time to prepare for this
yes,
with your attorney, and you've been satisfied with the representation of counsel?
yes.
All right, thank you. And so counsel, if you could just catch me up for a moment, this is a sentencing, is it a sentencing on the probation violations? Did you plead to those?
That is correct, Your Honor. At the time he entered his plea, I was actually not appointed yet. I was present in the courtroom, so I kind of had a little bit of background information. But he was, at that point, counsel had not been appointed. Mr. Green was advised of his right to a counsel, elected to plead guilty without counsel at that point, and then subsequently we were appointed to assist with sentencing.
So the alleged violations, or well, I guess I'm not alleging where you pledged them, but just so I'm clear, were failure to be placed on JSG teller prior to release from jail, therefore failing to complete 90 days, and that would be 90 days teller. Count 2, failure to contact probation agent after he was released from jail, and that would have been within 24 hours as the standard order. And then count 3, failure to contact or report to probation as directed upon release.
That is correct.
That's correct, Your Honor.
That's correct, Your Honor. And had I known that he was being arraigned or in custody, I would have updated those violations with a little additional wording, as I know how you like things to be worded.
Yeah, thank you, I appreciate that. And I do have a recommendation from probation. And that was that done by you, Ms. Farr?
That's correct, Your Honor.
Okay, are there any corrections, additions, deletions?
There are not, Your Honor.
On behalf of the people, any corrections, additions, deletions?
No, Your Honor.
On behalf of you?
No, Your Honor, thank you.
All right, sir, have you had an opportunity to go over this with your attorney?
Yes.
All right, on behalf of probation, what is the recommendation?
Thank you, Your Honor. As I had mentioned, I inherited this case. I have never personally met Mr. Green or had the opportunity to work with him. However, since sentencing, he has proven to this court that he does not want to be under community supervision as he continues to abscond from probation. Therefore, an adjustment to probation cannot adequately be measured. It is very concerning that since 1999, he has been a sex offender. And the delinquent charge was dismissed as part of this plea agreement in this case. So his history in itself is very concerning, and this may be someone that should not be out in the public, being that he is a sex offender. But my hands are tied right now with my recommendation to revoke probation at this time. His guidelines are 0 to 34.
So is this the first violation?
This is his second violation, Your Honor.
But there are multiple violations. So this doesn't count under the 3 violation rule?
Well, I know every judge counts the technical or non-technical ones differently, but if we go that route, then at this point, yes, we could recommend a prison sentence on him.
On behalf of the people?
Your Honor, I would defer to probation. I don't have a strong opinion, I guess. I mean, ultimately, he's clearly not a candidate for probation. I think we're setting him up for failure by leaving him on probation. If the court is inclined to adopt the 365 credit 248, the people would be in support of that, but would not be opposed to providing more information if the court requested it.
Counsel?
Thank you, Your Honor. I did have the opportunity to speak with Mr. Green. What I will mention that I found pretty impressive when I witnessed Mr. Green enter his plea before the judge, he did not make excuses. He took accountability. He knew he had an obligation to report to the court. What was interesting when I spoke with him is I got a little bit more information about why he failed to report to the court. Since his release from custody, he was essentially homeless. He doesn't have any ties to the Lansing area. He has since reconnected with his mother, who is in Detroit. That's the only support system that he has. He is a veteran. He does have some issues tied to his prior service. He did serve in the Army. He ultimately, though, I think what it boils down to in terms of his failure to comply has a lot to do with his indigency and lack of resources. That being said, we understand that the recommendation is to revoke probation. And Mr. Green still remains concerned as he does not have a stable source of income, reliable transportation. So he genuinely remains concerned about his ability to comply with Ingham County probation. He thinks if he were to be continued on probation, he'd be much better suited in having that probation transferred to Wayne County. It'd be much easier for him to comply with things there. However, if the court is inclined to revoke probation, we would respectfully request that the court follow the recommendation in the report to 365 days jail in Ingham County with credit for 248 days previously, sir. Thank you.
Sir, what would you like me to know?
Well, I think it's all been said.
Well, sir,
If you have any questions.
well, yeah, I have questions. I understand you're indigent, homeless, it's difficult to comply, but you actually pled to aggravated indecent exposure with habitual fourth, so that would be punishable by, let me see, it's only a 2 years, so it would be what, 15 year now? So you could be sentenced to prison up to 2/3 of the 10 to 15. What have you not understood? My issue here is in 2000, you were convicted of CSC 4. You were also at that time convicted of sexually delinquent person. And you were convicted in 2001 of CSC 4, criminal sexual conduct 4. Now we have aggravated indecent exposure. You have this uncontrollable urge that has taken hold of you. How are you going to change, sir? Because I can get you treated in prison. You don't have enough jail time left. So what are we going to do about that? You want to go to jail and then probation? You want to go to prison? I don't usually give people choices, but sir, you cannot endanger others with indecent exposure or criminal sexual conduct. You are a registered sex offender, correct? You still registered? Yes?
Yes.
So you have to have an address and check in and do all those things. So I'm concerned about how we get to safety of the public. What is your proposal?
What do I think you should do?
Well, how do you think you can remain free of this?
Well, I really much wanted to go home and do probation, as she told you. I could not. They don't help you at all. You know, I get out of here, released from the jail last year. They do not put me on tether. They tell me I have to report to probation tomorrow morning. I have no money. They don't even give me a bus ticket. I had to beg for a ride to get back to Lansing. Then I have to get back to Detroit after I report to probation. It was impossible for me to do. I had no money, you know what I'm saying? And, I just, for the past year, I just have been on the streets in between Detroit or Ann Arbor or here, you know what I'm saying, with this warrant hanging over my head. I tried to contact my probation officer, but she had left Ingham County or whatever. So I don't know if I could go home and, to my mother's house and do my probation there. But she says that, I mean, you don't want to send me to jail. You want to send me back to prison. Is that what you're saying? If that's the case, I don't know, but she said that I would, just have to do the jail time.
Well, she doesn't get to decide.
I
She
know.
promised you that, she's wrong.
No, it's not like she promised. She said that's what was recommended.
But that was what was recommended, but I don't know that that's enough time because you've not availed yourself of any help, and I understand being indigent, but we do have an indigent grant for indigent GPS, and they should have done that for you. I don't know, it looks like there's been a lot of breakdowns.
Your Honor, I just wanted to bring it to the court's attention that he has not registered since May of 2022, and there are charges that are waiting to be sworn on for failure to register as a sex offender. So that's another issue. Thank you.
So I can't even release you, sir. There's probably a bench warrant or something out there. Will be, you failed to register.
Well, it's been 2 years, 3 years.
Well, 2022, 3 to 4 years.
Yeah.
Yeah, so what are we gonna do with that?
Well, if there really is a warrant, I guess I'll be back in court.
Poverty is not a roadblock to making a phone call or walking to court and saying, here I am. In fact, probation is meant to help you, sir. If you met with our probation agents, they're gonna help you sort out when to report, what's going on, how to get housing, there's resources. The Public Defender's Office also has resources to help you. Going to Detroit should have been mentioned a year ago when you were in front of Judge Stokes, and I'm certain Judge Stokes would have said, go to Detroit, let's do probation where you have housing. I don't know anything about where your mother lives, or if as a sex offender you could even live with your mother. Does
Yeah, I
anybody
live
know?
with her.
Well, she might say you can live with her, but the law might not say.
I did parole at her house for 4 years. So I'm
Were
certified.
you
to live.
successful on parole?
Yes, I successfully completed parole.
What stage are we at with this bench warrant or cases gonna be issued?
Your Honor, it looks like my office authorized it in early January of this year. Mr. Buxton is looking to see what or why it has not been sworn to at 54A District Court, but we did authorize that one count again as a have fourth offender in early January of this year. So I anticipate it will be in the system, for lack of a better way to put it, this week. Well, I guess on Thursday, so maybe next week.
All right. Here's what we're gonna do. 365 days. Jail. 5 years probation. You will be released from jail with a GPS tether. Probation can be transferred to Detroit, provided defendant's mother's house is a viable address and compliant with SORA. he can report to probation as reasonably available, meaning in person, Zoom, phone, and that would be as directed by probation. The people are directed to deal with this, swear to, either make it happen or make it go away.
Yes, sir.
He is going to comply with SOAR requirements immediately. Is there anything else I need to add, Ms. Barr?
Your Honor, the only thing I can think of is that if we're going to continue and extend him on probation, that he can complete sex offender training.
Yes.
And that is a condition on there already, and have housing and meals provided at KPEP. If your honor so wishes to also order that.
So, yes, so tell me about the KPEP.
It's a residential treatment facility and they do, they accept sex offenders and they specifically do, all the sex offender, programming.
So I've sent him to jail, right? So are you suggesting instead of the jail time, he go to KPEP?
We could suspend the balance upon, transfer to KPEP. I just think that may be more beneficial for
Great.
him. But would you still want him on tether while he's there? Because we can
Yes.
yes, thank you. Yeah. Your Honor, how long would you like that term of?
Longest term available, he needs the treatment. We have a history here and eventually he's going to be sentenced to life.
Yes, Your Honor.
I have completed KPAC twice.
And it didn't work?
Well,
You wanna go back, sir?
well, you clearly sending me back. I didn't,
Well,
I don't have any issues with it. I just thought you should know.
okay, I'm happy to know that. If that doesn't work for you, we just keep you in jail, put you on probation. But understand, with what you have, sir, it's a disease. It's a disease. And with that, you have choices. The choices are to continue the treatment, like any other disease, like a cancer. Or some judge, whether it's Judge Stokes, me, or some other judge, is gonna sentence you on some new case to life. Now, I don't know if you like that jumpsuit, that terrible food in jail, the bed there. If you do, then aim for it, go for it. But if you wanna be free, then you gotta follow the laws and you gotta stay in sex offender treatment. There's no end to it for you, sir. How old are you?
54.
54. So I don't know, God willing, you'll have another 50 years on this planet. Do you want to spend those 50 years? Because people are living a lot longer now. Do you want to spend those 50 years behind bars, watching, where people are watching you pee and eat and sleep and telling you what to do every day, or you want to be a free man?
Well, you try to go for free.
I hope you want to be a free man, but the only way you can do that is to treat this propensity that you have, this illness that you have, like a cancer. Only instead of going for radiation, chemotherapy, and all of that, you keep going for the rest of your life to sex offender treatment. Because otherwise you will be behind bars. There is no question in my mind. I have seen people like you every week for the 23 years I've been a judge. And I know the outcome here. I don't have a crystal ball, But you see, people act the same way. We're like animals. And so the history predicts the future. I want to change your future if you want to change it. If you want to go to KPAP, if you want to continue in sex offender treatment for the rest of your life, because we're going to lose jurisdiction over you after 5 years. But you need to put in your mind, sir, that you do not want to die in prison, that you want to go to your mother's funeral, have a few dinners before that happens with her, and live a free man. But the decision is yours. What is your decision, sir?
Well, you want to send me to KPEP. I can agree.
Sir.
In lieu of going back to jail, is that what you're saying?
Well, you go to jail and then you go to KPAP as soon as there's a bed available.
Okay.
Okay, but you see, I don't know if this new warrant that's coming out is gonna stop you from going to KPAP. But you're missing the larger message. The larger message is treatment for the rest of your life. KPAP will get you back on the treatment path, and then when you leave KPAP, you need to re-engage in treatment for these 5 years. I put you on probation. When that is done, you still need to go to treatment, because otherwise you're gonna be rearrested because you're going to reoffend. So I'm trying to tell you, heal yourself, stay a free man, keep everyone safe, or the next judge will likely put you in prison. And it could be for the rest of your life, because that's how these offenses go. And you have a habitual fourth, which means that you can be subject to up to life. In fact, the offense that was dismissed, sexually delinquent person notice, indecent exposure, is 1 day to life. You've avoided that. But I suggest to you, you take that seriously, because some prosecutor was gonna make that stick. Whether you go to trial or you plead, whatever. And some judge is gonna send you to life. There's a history here that I'm concerned about. I'm trying to get it through you that you have an illness. You have an illness. The treatment is continued therapy. You could also talk to some doctors about medication. I know you're indigent, but there are doctors who will see you. The community pays for that. And there's medication that can help you as well. I'm not a doctor, but I've seen sometimes on some cases, medication work for these kind of cases. But you have to take those steps. Do you understand what I'm saying?
Yes, ma'am.
So are you willing to continue the treatment or not?
Yes, ma'am. It's just, you just said that there's a new warrant issued. I won't be going to.
Well, I don't know.
But
It may
that's
stop you temporarily, but Judge Stokes could put you as a bond condition, or you, if you plead to that, or maybe it goes away. I don't know what's gonna happen there. I do
Yeah.
know you haven't registered. But I do know once you take care of that, I suspect Judge Stokes will also send you to KPAP.
All right.
Or, you know, I don't know.
Okay, but I'll be back reporting.
I've written her some notes, and we'll deal with this, but sir, I'm not willing to do KPAP if you're not willing to tell me that you're gonna be taking this seriously like an illness and stay in treatment the rest of your life. Cause I don't care when we lose jurisdiction, we're gonna get it right back, but you're gonna do the same thing again, unless you stay in treatment. Have I been clear?
Yes, ma'am.
Do you understand?
Yes, ma'am.
Are you willing to go that route?
Yes, ma'am.
Well, understand the consequence if you don't.
I did.
Time will tell, sir, but understand. Shut the door. Thank you. That was disruptive. Understand, sir. The consequence of you not staying in counseling is going to mean you'll lose your freedom, possibly the rest of your life. So let's continue the healing. Okay?
Yes.
Transfer to KPEP for treatment with bed, meals, SORA, counseling. mental health treatment, long-term SORA treatment to continue for full 5 years. And he's to follow all doctor recommendations. Those become orders of this court. No earned early release, no tether release, if he is remaining in jail because of this other file, but as soon as available, he will go to KPAP, and then the balance of the jail is held. Sir, if you run out of jail time, the next choice is, prison. So
If I run out of jail time?
if you run out of jail time and you violate during this probation, then you only have prison time left.
I see.
Do you understand?
You mean, if I go to KPEP before my jail sentence runs out? Is that what you're saying?
What I'm saying is, whether or not you go to KPAP, we're gonna get you there. And then you're gonna have limited amount of jail time left. Once the jail time is finished, okay, you're gonna be out there. But once if you're sent back to jail, once you spend or are credited for your 365 days.
Oh, I see what you mean.
Not over.
If I'm in here for the next week and then I get sent to KPEP, I still got like 100 days or something.
Whatever.
And if I get arrested a year from now or something, I got 100 days. If I run out of that, I go to prison. Is that what you're saying?
Yes.
Okay, all right. I just wanted to understand.
Yeah, because once you're out of jail time, the judge doesn't have any discretion. If they want to lock you up, it'll be prison. She can still use those unused jail time. But once you use all your jail time, it's prison. So don't give us the choice. Do the right things and stay a free man, a safe man, a healed man who continues in treatment.
Yes, ma'am.
He is to remain in treatment for the full 5 years, and I am not confident in Detroit. I am confident in you, Ms. Farr. So I want regular reports made about what's going on in Detroit.
Yes, Your Honor, and I thought maybe you would say something like that, but so I'm gonna make sure that this one does not fall through the cracks. I don't know what happened, what the reasoning behind JSG not putting him on tether to begin with in the first place. So I'm going to make sure that everything is completed for Mr. Green to set him up for success. I want these failures to turn into support and success. So the shelter right behind my office accepts sex offenders. I would really like the opportunity to work with Mr. Green once he completes KPEP. We can get him transportation back to Ingham County and get him into that shelter. So I can spend a little time with him, get him into Burgess sex offender treatment. I know that may not be what he wants, but it might be what he needs. So that was just an idea too, but I'll talk to him more about that prior to him going to KPAT and seeing if that's something that he is interested in for at least 90 days. Give me 90 days to work with him before we send him to Wayne County.
Okay, let me just write that. I'm gonna choice. So probation will continue in Ingham County for 120 days prior to transfer to Wayne unless defendant wants to remain in Ingham or probation finds Detroit unsuitable for any reason. How's that?
That's perfect, Your Honor. I have one more request.
Sure.
That I am the one who places him on tether prior to his release, so I can monitor his whereabouts opposed to JSG, who only really watches him via curfew, Your Honor. I'd like to keep an eye on Mr. Green, if that's okay. And I can deem him indigent, as Your Honor did, and enter that, so the MDOC does not charge him the $60 a month.
Okay, so Ms. Farr shall place tether on defendant as soon as possible. Is it MDOC tether that's gonna be placed on?
Correct, Your Honor. So I can monitor him.
MDOC.
If you're my probation agent and I have charge, I mean, isn't that count as a violation before the fact?
We're not charging you.
Oh, all right.
It's free.
No, I meant the charge for not reporting.
Oh.
She said there's gonna be a charge against me.
For failure to register.
Failure to
with-
register.
Correct, but we'll deal with that when it comes up. That's
It's
not,
up to the prosecutor. We can't get involved with that right now. The prosecutor, you and your attorney will work on that, but you may even ask Ms. Farr her opinion. I really don't know. But we have to deal with.
I see.
Okay.
Your Honor, I hear what he's asking.
Yeah.
And if we can now put it on the record that once that charge comes through, we not violate him on that charge.
Got it.
Is that
Sure.
acceptable?
Yes.
And maybe that will give him a little motivation to comply with his conditions of probation. Was that what you were asking, Mr. Green?
Yes, ma'am.
Perfect. Okay. Thank you. Yes, it will be. Okay.
I think we got it all covered. Any questions, sir?
Oh, ma'am.
All right. You've got 42 days to appeal and to request appellate counsel. Please give Ms. appellate rights. I'm not sure that we really need to, but I'm going to anyway, just to cover ourselves. If you're unhappy with this, you can appeal, sir.
Thank you, Your Honor. I'll get an amended order submitted.
Thank you.
Thank you.
Thank you, Your Honor.
If you could submit that to me under Judge Stokes' name, she's gonna be out for a couple days, so I'll sign it.
Yes, Your Honor. Thank you.
Your Honor.
Yeah.
What is current credit date?
Well, I'm sorry, we said days.
48.
Yes, I'm sorry, 248 with credit, well, 365 with credit for 248. And then the balance will be held upon his transfer to KPAP.
Thank you.
And we're good?
We've got officers. Thank you very much.
Good luck, sir.
Thank
No, it's not going to be. My understanding is,
Okay,
maybe that changes, but that's my understanding.
okay. So this. This one.
Well, we're not having trial tomorrow. Oh, wait, are we having trial tomorrow? We're not.
Is that where? Look, we're supposed to be a plea. He said it'll explain on the record, but
Okay.
it's not YTA. Well, class is YTA, but it's not. Just gonna know.
Maybe we try. That was the deal.
You and I.
This was a real simple.
This was like the worst one.
Your Honor, permission to approach on something totally unrelated. Thank you.
It's been off record, it's not sworn to us. It's just off record. It's faster.
It's so hard to find good help these days.
Yeah.
You got Phil in here, being supervised. What?
Let me double check that.
Right?
I don't know.
That's the one I fed to the vending machine down there.
Yeah. It's all.
Josh.
Was this, for Christ's sake?
Yes. We can't do a plea, so can we get an update?
I don't know if we want to go on the record, explain what's going on.
There's something in the pipe, so we gotta get that figured out. All right.
We don't need to go on the record.